everyone, and welcome to another episode of Legal Sharks. Today we have with us Advocate Sumit Nagpal, Managing Partner, Nagpal and Associates. Sir also has been a journalist, which makes him the perfect person to have a discussion on emerging challenges that we face in intellectual property rights. So, sir, without taking up too much of their time, how does it feel to be back in a college campus surrounded by young minds?
I remember my guru, Mr. Ram Malani, when I started teaching, he told me one thing. He said, the older you get, the younger should be your company. And I looked at him, what are you saying? He said, take it in a positive way. When I say the younger should be your company, it means that you should keep interacting with young students. And he encouraged me to get into teaching. I started teaching media law to journalism students in various schools. I taught at Bharatiya Vidya Bhavan, I taught at APJ Media School, I taught at Arohan Media School, and right now I'm teaching at IMC. It is one of the premier institutions when it comes to journalism education in India. So interacting with students has always been I would say a passion. I feel younger, I feel energetic, and it feels lovely to interact with young minds. I get so many ideas talking to them.
I am sure, sir. Interacting with kids is absolutely a pleasure. I mean, they keep us, I think, young. The kind of vibe they bring, I absolutely get that. So, a very interesting thing, I think, in your career journey has been how you've transitioned from being a media person, from being in journalism, to coming to the field of law, that to IPR. And from what I hear, you are still very passionate about journalism. You still
Yes.
teach the subject. So, what made you actually go from being a journalist to coming to the field of law and taking up a niche area like IPR as your area of specialization?
I can say that so many times I've been asked this particular question that how you shifted from journalism to law practice. To be very frank, law was always there from the very beginning. When I completed my PG diploma in journalism way back in year 2000, I asked my father, I want to do law. He said, what is your plan? Either you want to become a lawyer, you want to become a journalist. I said, I want to become a journalist, but law is something I'm in love with. So that love continued. I did my law at that time,
Okay.
and I got my first job, and my editor asked me, what do you want to do? I said, I want to cover law. I want to cover
Okay.
courts. So to define my relationship with law and my journey shifting to law practices, I was in a live-in relationship with law. Finally, I decided to get married to it. So this is how I shifted. And yes, journalism remains a passion for me. I still appear on TV. I still teach media law. I guide a lot of media persons, and PTI is one of my clients. So journalism has always been there in my life. I would say that the initial 10 or 12 years of my career, they were dedicated to journalism. But yes, uh, I also understand, I want to tell you that when it comes to my beat, the legal beat, your financial stagnation is there. There is a limit to what you can earn in a job when you are a journalist covering law.
Right.
So that was the problem I was faced with, and I am someone who is extremely interested in finance. So I thought, how do I increase my income? Then I thought that shifting to law practice will give me two things. I'll be more satisfied when it comes to financial aspect of my life, and secondly, I'll be doing, because आपने एक हिंदी में टर्म सुने होंगे, तटस्थ. I was a watcher of law.
Okay.
I was always in the backside of the court, just writing what the lawyer is arguing. But when you get into this, then you start arguing yourself.
Right.
So that was something I wanted to do, and there were two reasons. One was financial stagnation in journalism, and secondly, I wanted to practice law. So then I shifted to law practice, and if you ask me why IPR, in the beginning, I did everything. I did matrimonial cases, I did consumer cases, I did some of the property matters. But my wife is also a lawyer. She was the one who was practicing intellectual property rights. So she told me that we have to have one particular field we have to specialize in, and IP and media law is interconnected. If you see copyright
Yeah.
law, if you see media law, they have
Absolutely.
like connections with IP law. So that is how it was very easy for me to understand, and I was interested in it, and I found this very interesting, IP law. So then I continued my journey in IP law, and I stopped doing all the matrimonial cases, all the property cases, because by God's grace we got so much work of IP. So I did not want to do anything else, but right now I practice media law, IP law, and cyber law.
So, sir, from what I understand, you coming into this profession of law was both a practical decision and an emotional one. Like it was your desire to be a lawyer as well as practical
Yes,
considerations.
yes.
And for picking IPR, it was guidance that you received from your partner. So, because a lot of these students who are sitting here and a lot of the kids who will be watching this, I think they also seek this kind of guidance because they also have to make this huge decision of what they'll do post completing their degrees, what area they'll get into. So, any suggestions for them? What should they think about? What factors should they keep in mind when they're making this decision?
The basic thing which I would like to tell to every aspiring lawyer, and to only those who want to get into litigation, this is for
Right.
them. They have to first learn, and then they should think of earning. First learn, then earn.
Right.
Because I tell to every young lawyer, LLB करने से कोई वकील नहीं बन जाता.
That is true.
वकालत जो है thought process है. You have to think like a lawyer to be a lawyer. And I deal with so many kids, and I tell them why you are pursuing this particular career, because what is missing is that they do not think like a lawyer. When you are a lawyer, सबसे पहली चीज जो मैं सिखाता हूँ, शक करना सीखिए.
Right.
शक करना मीन्स रिलेशनशिप में शक करना नहीं कहता मैं. डॉक्यूमेंट्स पे शक करना सीखिए. एवरी डॉक्यूमेंट यू कम अक्रॉस, डोंट बिलीव दैट दिस इज ट्रू.
Absolutely.
If you give me like few minutes, I'll tell you a very interesting case. शक करना कैसे होता है? I shifted to law practice, and I got a trademark infringement case. And in trademark infringement cases, the prior user gets the rights of trademark. So I sued someone on behalf of my client, of course, and that person, we had a user claim since 1995. That person, very smart, he filed his written statement. He said, no, 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 I am using this trademark since 1994. And I didn't know what to do. I was new in law, and I kept thinking that this guy has claimed prior user. हमारा तो केस ही उड़ गया. Then I saw at his written statement, I saw at his documents. First few invoices which he filed, I thought कुछ गड़बड़ है. There's something fishy. I kept thinking about that. And you cannot even imagine how I won that case. I kept looking at the invoices which he had written 1994. Then he had filed his income tax returns, then he has filed some photographs that these are that was the event management company. And I didn't know what to do. One fine day, after looking at documents 100 times, I could not understand what to do. I just saw at the phone number, landline number. It was an Airtel 8-digit number. Immediately it clicked into my mind. 94 में 8 digit का तो number ही नहीं होता था. Immediately I did some research. When did Airtel launched their service? It was, I don't know what was the date at that time, but it was probably 2001, 2002. And at that time, when they launched their service, they had a 7-digit number. So on the invoice, which was from 1994, there was an 8-digit number of Airtel. Then again I kept thinking what to do, what to do. I again scanned the documents. Then I saw his income tax return, which had his date of birth. In 1994, he was not even 18 years of age. So he could not have filed his income tax returns. These two documents I got, and I went to the court and I told the judge that they have forged their documents, and because of this, they are claiming prior user and injunction should be granted in our favor. I still remember the name of the judge. It was very first cases I did when I shifted to law practice. His name was Sanjay Kumar. The learned judge told the defendants, आपका केस उड़ गया है, आप settlement कर लो. That guy, very senior lawyer, I respect him a lot, from the opposite side. I told him, sir, फर्जी documents नहीं चलेंगे. Immediately, we got the injunction. That was the first order I got in my favor. And 6 months down the line, that case was settled. Because the other party knew that ab gaye hum kaam se. So when I say, when you're a lawyer, shak karna seekho. Every document you see, don't go by the face value. हर चीज को ध्यान से देखिए कि इसमें क्या गड़बड़ है. Because when you're a lawyer, people come to you to seek guidance, and you can only guide when you have an independent thinking mind. If you go by the face value कि जो लिखा है उसको मान लिया, you will never be able to become a good lawyer.
Right.
This is the first thing you need to do. शक करना सीखिए. Yes.
So,
I hope students would have learned from this.
so the takeaway from this is that always verify before you trust something, and always have an eye for detail.
Never trust anything. Never trust. Whatever comes your way, every file, do not trust what is written. Because if you are a defendant, the plaintiff would have made 100 claims that we are this, we are that. You have to deny everything, you have to give a counter to everything, and you do not have to trust anything.
Right. So, diving a little bit into your area of expertise, which is IPR, and the emerging challenges in the field. So, we keep hearing how artificial intelligence and other emerging technologies, they're changing the landscape of various industries. To the extent that at this point, it is even being used in our justice delivery system.
Yes,
We
I
have-
do it extensively, by the way.
I am sure all of us are using AI a lot. So, how do you think that the IP law framework that exists in India right now, it needs to adapt to this huge change that has come? I am sure it will take time, it will take 5-10 years, but what are the changes that should be adopted, that should be implemented?
See, if you ask me from the point of view of the intellectual property rights law, then obviously there is a challenge when it comes to the content which has been created with the help of AI.
Right.
If artificial intelligence is writing something, who owns the copyright? If AI is creating a video, who owns the copyright? These are the challenges which eventually the legislature as well as the court will decide in future. Right now, I do not know how many of you know that when it comes to your social media accounts, It is your picture, it is clicked by you, but you do not own the copyright. How many of you know this? Do you know? Every picture you post on Instagram or Facebook, you do not own the copyright on that image. Because when you sign up for Facebook or Instagram or any other social media platform, you sign the terms and conditions which nobody reads. But those terms and conditions have a condition that you do not have the copyright on these images. Similarly, the framework, I would say the government is also working on this, the legal professionals are also thinking about it, because when it comes to AI generated content, whether the copyright should lie with the software owner like ChatGPT or Grok or Google Gemini, whether Google will be owning the copyright of the content which has been created with the help of their AI engine, or the user who is using it. These are gray areas right now, but eventually clarity will be there. The government as well as the courts will eventually come up with the mechanism to deal with it. Right now, I would say that when it comes to the ownership of copyright, I am telling you a very interesting thing. When you give a prompt, then the AI works.
Right.
So, it is your idea which has been fed into AI, which has come up with certain content. So, eventually the owner or the writer of that prompt will have some right in the content which has been produced.
So, but what about a situation where we happen, this is honestly just my doubt, that when we try to train AI to operate on a particular data and come up with further analysis or an outcome, what happens to that outcome? Whatever
That is
outcome
I am trying to
on
tell you.
data that is trained.
See, when you have trained the AI engine, in that case you will have some amount of right, because whatever content has been created, it has come out because of your intellectual labor which you have put in when you are giving the prompt. When you are training the AI engine, it is your intellectual labor which you are doing. So, eventually the person who is giving the prompt will have some right, but yes, this is a new area, it will take time, the courts will have to examine such issues, and eventually things will be more clear in the future.
So, what is your take on courts using artificial intelligence in analyzing judgments? For instance, right now we are in the first phase of implementing AI within our justice delivery and enforcement system. So, without any regulations, without any framework, we're doing this. Do you think that there are any risks associated with it? Things that we should exercise caution against?
If you have seen the first Spider-Man movie,
Right.
first Spider-Man movie, Uncle Ben told Peter Parker. What was the quote which Uncle Ben told Peter Parker? Yes. With great power comes great responsibility. AI is a great power. So, when you use AI, you have to be mindful of certain things, the risks attached with the AI.
Right.
That is called AI hallucination. AI hallucination is a case where AI will create cases. AI will create cases, fictitious cases. They will give, the AI search engine will give you fictitious cases, and those cases sometimes we had seen in the past that the courts were very angry. I am talking about the foreign courts. They were very angry, and sometimes the lawyers were chided also, they were given warnings also. And in India also we have seen certain cases where AI content was used in the pleadings. So, when it comes to AI, artificial intelligence, again come back to the basic, never trust anything. If AI is giving you something, you have to apply your mind.
Right.
Because people always tell me, what is the future of lawyers? AI will draft everything. I tell them, AI can tell you what to write, but it cannot tell you what not to write. It is only a lawyer's mind, analytical mind of a lawyer, which can tell you that this is not to be written. This is against our case. AI will not be able to do this. So lawyers cannot be replaced by AI. That is a good news. But at the same time, you have to see AI as a tool. Just like Google, we used to use Google few years ago. It was just a tool. AI, I have been extensively using AI. Suppose I have to send identical notices. Check bouncing, identical notice. You have to just write this is the amount, this is the date of the check, and this is the bank. You have to write identical notice. You can train your AI to write notices. The notice will be prepared. आप उसको जैसे जूनियर ने काम करके आपको दिया, आप चेक करते हो, ऐसे ही AI ने आपको काम करके दिया, आप चेक करो, उसको आगे यूज़ कर लो. Similarly, मेरी emails अब मैं नहीं लिखता. I have stopped writing emails since last 1 year. I tell my AI, this is the document I have to send it to a client. Please write a mail. AI will write a mail. If I to make a case, even I'll tell you, if you are drafting a document, I'll tell you how to use AI. If you upload a full plaint and tell AI, इसका written statement बना दो, that would be the worst written statement you can see in your life. It will draft. But you have to know how to use AI. You have to upload a written statement which has already been drafted. Then you have to tell them individual para, इसका जवाब बना के दो, तब AI आपको बना के देगा. So you have to be mindful of the fact how to use AI. And one basic thing, never trust what AI has written.
Absolutely.
Never trust. जैसे एक जूनियर मेरे सामने ड्राफ्ट लेके आता है, मैं आई एम माइंडफुल ऑफ द फैक्ट इसमें गलती हो सकती है. सो व्हेन एआई इज जनरेटिंग सर्टेन कंटेंट, आई विल ऑलवेज बी लुकिंग एट इट as if some junior has drafted it. I have to check it. This is how AI has to be used. Right. And I don't see any threat because of AI. The only threat because of AI is that now when you're dealing with the clients, they would have read about this subject on AI and they would come with 100 suggestions that ये कर सकते हैं, ये कर सकते हैं, मैंने सब पढ़ रखा है. But again I'll tell you, AI can tell you what to do, but AI can never tell you what not to do. This is the job of the lawyer. So I have to decide that I have to pick up this particular option for my case.
So AI can be very beneficial if used with caution and after due verification.
Yes.
So
I'm using it extensively, I can tell you.
sir, of course, for research, AI is obviously non-negotiable. It makes your job much easier. But at the same time, using it without caution, as you're saying, without verification, that can be harmful to you. So another area where I think a lot of debate takes place is the use of IPR in certain industries like pharmaceutical industry or technological industries, where it is often argued that intellectual property rights prevent further research on the subject or create monopolies in a particular area, hence preventing further innovation. So what is your take on that?
IPR will never prevent the research or further innovation. But I do agree to an extent that yes, at times it creates monopolies. See, you have to understand what is intellectual property right. Intellectual property right is a right which you get because of your intellectual efforts. When you are putting your intellectual efforts, think from the angle of an innovator. The person has invented something. The person who has invented something, he must get the benefit of his intellectual labor, and this is what IPR does. But again, you have to understand that on the one hand, intellectual property rights give that person a monopoly, but that monopoly is not till eternity. It is for a very limited period. If you talk about pharmaceuticals, the patent which is granted is for 20 years. And if you see the reality, what happens, getting a patent is a challenging job, because when you file a patent, it takes at least 5 to 7 years to get a patent, then you can enforce it. And out of total 20 years, 5 to 7 years gone because of this,
Okay.
fine. And sometimes I am doing some cases in which I have seen that the patent has not been granted, and they filed an appeal before the High Court stating that this patent should have been granted, and that period of 20 years is already over
So patents are granted from the date of application.
from the date of application.
Okay.
But I am just telling you that there is a balance. On the one hand, it creates monopolies to give reward to the person who has innovated.
Right.
On the other hand, this particular reward is there for a limited period of time, that is 20 years at the max. And when it comes to copyright, I would say that it is an intellectual effort, and the term in this case is very long, like when it comes to some, like you have written a story, literary work, from the day the creator dies, then till the 60 years after his death, the copyright is granted. But just imagine if a songwriter, he has written certain songs, beautiful songs, and after he gets old, the only money he gets is royalty. He has no other source of income. So, if intellectual property rights are not there, the innovators' rights will not be protected. The rights of the lyricists, the songwriters, or film story writers, or so many people who create music, who make films, who make paintings, who do so much of literary, dramatic, artistic work, they'll be left with no option, because in their youth they did something, and this is the time when they get old, this is the only income they have. So there is a balance between the two, I would say.
So we need to strike a balance between
The government has already done it, and I think 20-year period is a good time where the innovator can get the reward, and there are checks and balances as well. Suppose somebody has invented something, and that person is not using his invention for the benefit of society. In that case, there is a provision of compulsory licensing in patent law. Somebody can make that particular product which is patented, and he can apply to the government that this person is not using his innovation, this particular invention should be available to the public, and the government will fix the rate on which the royalty will be paid to the innovator. Compulsory licensing is there. There are checks and balances. So it's not that if you have got monopoly, nobody can do anything about it.
right.
You can get compulsory license.
So I think, sir, your answer has clarified a lot of IPR myths. It has broken a lot of IPR myths today. For instance, it's very interesting to know that patents are actually granted from the date of application, and the application process itself is very long. So that is very interesting to know. I'm sure this practical piece of knowledge will be very helpful for the students also. Sir, apart from this, another issue that we constantly keep reading about, and it's constantly discussed in countries like India, which have a lot of traditional knowledge. Traditional knowledge that does not neatly fit into any in the present IP law framework that's here. So how do you think that this framework needs to evolve? What changes should be brought in order to accommodate or protect this traditional knowledge that is existing in India?
See, when it comes to laws like geographical indications, GI, it protects your traditional knowledge. How Banarsi sari is made. So only the people of Banaras, they specialize in Banarsi sari, they get the GI tag. Nobody else can use that particular GI tag. So that innovation, that traditional knowledge is already protected under GI law, but there are certain other aspects
Right.
also, like uh, we had seen in the past that some companies are trying to patent, they were trying to patent haldi.
Yes, exactly. That's where
Yes,
the
yes,
controversy
yes.
started.
So India is very proactive when it comes to such cases.
Yes.
Indian government is very protected when it comes to intellectual property rights. They will file opposition, they will file cases to prevent such monopolies. Somebody
Right.
will say we'll patent basmati rice. This is Indian variety.
Exactly.
So plant variety act is already there. So GI law is there, and trust me, when it comes to Indian government, and specifically I'm talking about the departments of patent, trademark, copyright, GI. So this department, this ministry has been extremely proactive in doing so. They file oppositions, they prevent such monopolies being created throughout the world. I'm not talking only about some big countries. If anywhere in the world somebody is trying to create monopoly over something or some knowledge which belongs to India, Indian government steps in. So they do it very proactively. I've seen such cases.
Right, sir. Sir, I think another area that I'd like to discuss with you, get your insights on, uh, is because we're talking about our government stepping in to protect our interests on the international stage. So, a lot of the IP standards that have been set, they've been set by Western countries, developed countries. Uh, and often they do not take into account the interests of the global south, which is still developing, which we're a part of. So, how do you think that affects small businesses here, or maybe Indian startups? How does it affect them? What are the challenges that Indian startups are facing today when it comes to protecting their intellectual property rights?
See, when it comes to Indian government, be it any party, whether it
Right.
is BJP,
Yes, yes,
Congress,
of
or
course,
any
sir.
party, I'm talking about the government. Indian government has been very proactive when it comes to Indian people who cannot afford much. See, when it comes to certain treaties with certain countries, I'm not naming the countries here, but one treaty, free trade deal with a big country is pending. India has not signed it. Do you know that particular country wants access to Indian market? They want to create monopolies in Indian market, and Indian market, which is you call rosy roti of the middle class and the lower middle class.
Right.
Indian government has not signed those treaties till now. One. Secondly, when it comes to protecting the Indian public, you just see the kind of steps which have been taken by the government. Corona vaccine,
Right. Yes.
Western companies who had developed it, they had the patent over it,
Yes.
but it was allowed in India. Secondly, very interesting thing I'm trying to tell you. Have you ever thought about sports signals?
Sports signals as in?
It means broadcasting rights of
Okay.
cricket
Yeah. Yeah.
matches.
Yeah. Right. Yeah. Yes, sir.
Earlier, Supreme Court, probably it was 2003 or 4, I don't remember the exact year, but it was in 2003 or 2004, if I'm correct. Supreme Court had allowed the signals to be rebroadcasted on Doordarshan, for which the foreign broadcasters had won the broadcasting rights, saying that it is allowed in public interest. Then Indian government came up with the law that every sports signal in which Indian matches are involved will have to be shared compulsorily with Doordarshan or Prasar Bharati. So, when it comes to protecting the public, when it comes to protecting the middle class or the lower middle class, government has been very proactive, and I don't see any instance where monopolies have created any problem for Indian public.
Okay.
When it comes to life-saving medicines, when it comes to cancer medicines, in India, there was a famous case, uh, Cipla versus Roche or something. I don't remember that case right now, but it was a very big case in which Indian manufacturers were allowed to manufacture cancer medicines just in public interest. Indian government or the Indian Supreme Court did not allow the foreign company to have a monopoly, because that medicine was selling probably at 1 lakh rupees per month. The medicine, the cost of medicine was 1 lakh rupees for the patient, and it was reduced to 10,000 by the Indian manufacturer.
Right.
So that was a big judgment the Indian Supreme Court gave, and I don't think that there is any scenario which Indian Supreme Court or the Indian government has not taken care of the interest of the middle class or the lower middle class in this country.
So, sir, if I am getting it right, per you, there is no need to adapt for the international standard to adapt anymore, to bring in any changes for countries that are still developing, which still have smaller businesses, which still have startups which are failing to protect their rights. There's no need to bring any change. The international standards are
See, the point is, when it comes to international standards, we have to adopt to international standards. We had signed Paris Convention, we had to
Right.
change our laws. See, our Trademark Act was amended, our Patent Act was amended, our Copyright Act was amended, because we signed the Paris Convention. So, our law, when you compare with the Western countries, we are very, very developed. Our jurisprudence is excellent, and I would say Delhi High Court has taken the lead when it comes to intellectual property right cases. Their judgments are quoted outside as well. And you will be surprised to know, when it comes to other countries like Pakistan, they cite Indian judgments when it comes to IPR matters. So, I would say that we will continue to evolve, because law is something, it does not stand still, it will continue to evolve. We will keep getting new situations and things will continue to evolve. So, we will change, we will adopt, but yes, we change subject to a fact that our law, our enforcement should be in public interest. It should be for the benefit of public. So,
Right.
this is how the law has evolved in this country. We are maintaining the highest standards. We have amended our law as per Paris Convention. We are, I would say that when it comes to our jurisprudence, it is just as good as any Western country jurisprudence. But yes, we do take into account the public interest.
right. So, essentially, it is us who need to be more in line with the international standards to make our IP framework even more effective. And to a large extent, we've already done that.
We have already
and
done
we
that.
will keep doing that.
I will say that now the time has come that India has to lead the IP landscape of the world. It is not that we will follow the world should follow India. We will be giving them precedents that this is how things should be done. So, I will say that time has come, India will lead in future, because you have to understand one thing, when it comes to IP and innovation, where, in which country the IP is needed the most? The company which is manufacturing.
Right.
Fine, they have to file patents, they have to file trademarks, they have to file copyright, they are creating. So, when it comes to the world economy, right now you see how many countries are there for manufacturing. First there is China, second there is India.
Right.
And Mr. Donald Trump, why he says make America great again? He wants manufacturing to go back to America. So, India is taking the lead when it comes to manufacturing. Our economy from 10 to 15 years down the line, we are going in a way where we will be like protecting manufacturing, we will be encouraging manufacturing based economy. So, in future 10 to 15 years down the line, India will be filing patents across the world, India will be filing trademarks across the world, and we will be leading, because we will be manufacturing.
So one last question, I think something that our audience will be very interested in, because a lot of our audience here in the studio and the ones who will be watching us also, they'll be young creators who are creating and posting on various social media platforms and are trying to build a career out of it. What do you think they should keep in mind uh, in order to ensure that their legal rights, their intellectual property rights are protected? What are your tips for them?
See, when it comes to creators, I would say creators have to be aware of their rights. First of all, right now we have Google, we have AI. With the help of internet, they should first make them aware that this is what we can do, this is what we cannot do. And I don't want to name a news agency, but that particular news agency had sued some of the YouTube creators who were using some of the content which was originally produced by that particular news agency. So, creators have to know that when it comes to law of fair usage does not give them absolute immunity from the copyright law proceedings. They should first protect themselves. See, first when it comes to creators, they have to first protect themselves and then they should think of enforcing their rights. So, first protect yourself, use as original as possible the content which you are using, use as original as possible. One. Secondly, if you are using somebody's content, try to take their NOC or try to take their subscription. And I deal with so many cases in which you have used one picture which belonged to some company. They are supplying pictures, photographs to the news agencies, to newspapers, to websites. If you have, even you have not earned any money out of it, you just used a picture. I have just dealt with a case where the person who had posted a picture on their company page for some New Year greeting or something like that, they were served with a notice of 15 lakh rupees that you have used this one picture of ours.
Okay.
So, we had to get it settled, we had to regularize that particular usage. So, when you are using something, some content from internet, always be aware of the fact that this can lead you into trouble. So, you use as original as possible created by you. Secondly, when it comes to enforcement, they should know that your rights are protected. They should file copyright applications, but sometimes it is not practically possible. Every day you are creating a video on YouTube, you cannot keep
Exactly.
on filing every day. I have created this video, I am filing a copyright
Right.
application. So, that is not possible, but yes, you should keep in touch with some good IP lawyers. I am not promoting myself here by the way, but you should continue to remain in touch with some good IP lawyers. So, if somebody is misusing your content, half the time in IP cases, my experience is that if you send a legal notice, half the time the cases are settled just through a legal notice only, because nobody wants to get into unnecessary litigation. So, copyright creators, either if you do not want to hire a lawyer even, just have one legal notice drafted with the help of some lawyer and you should send it on your own legal letterhead. So,
Right.
you should try to enforce your rights.
So, a basic knowledge of
IP
IPR
is must.
is must for anybody who is in the business of creating
Yes.
anything. And legal consultation, of course, is
And to creators and to everybody who innovates, who want to create anything, please note that ideas cannot be protected.
right.
Your work can be protected, but idea, you cannot uh, uh, allege that somebody has stolen my idea.
Right.
Even if you allege, you will not be able to take any legal action because ideas are not protected. Your
Right.
work is protected. So, whenever you do some work, try to protect it as soon as possible.
I think, sir, that is another IPR myth that you've busted. Because a lot of the students who start studying IPR, this is the first confusion that they have.
That ideas can be
Yes,
protected.
yes.
No,
This is,
ideas
I think, the
cannot be
first
protected.
topic in the syllabus that we cover when we teach
Ideas
them
cannot
also.
be protected. Your work, which is the result
Yeah.
of that particular idea, that
Yeah.
work can be protected.
Right.
Suppose you had an idea that I have to write a story like this. If you do not write the story and you had an idea in your mind, and you shared it with your friend, it cannot be protected. But yes, when you write a story, it can be protected. You had an idea, this is how my brand has to be there. If you have an idea, it cannot be protected. But if you launch your brand, if you do some billing on that, that particular brand can be protected. If you innovate something, you tell your friend that this is the invention I'm going to do, you cannot protect that innovation. But yes, if you actually produce that particular product, if you actually do it, then that product can be protected under the law of patents.
So, I think we've all learned a lot from you today about the area of intellectual property rights. Before we end this, is there any piece of advice that you would like to share with our young lawyers and the people who are going to watch this? Any last piece of advice?
When it comes to my final piece of advice to the lawyers who want to get into litigation, my two-word advice is learn and then earn. First 5 years, try to learn as much as possible. Don't think of earning. Law practice is like compound effect. If you continue to put in your efforts in law practice, then it will reward you handsomely. Law में कोई भूखा नहीं रहता, ये याद रखिएगा. Every lawyer makes money unless you don't want to make money. So first, pay attention to learning, and with great respect to every student who wants to get into corporate law, please have this clarity: what is corporate law? Corporate law, in-house counsel जो होते हैं वो भी corporate lawyers होते हैं. When it comes to the lawyers who do not get into litigation but who are into compliances, who are into capital market, who are into mergers and acquisitions, who are into labor compliances, who are into this IP compliances, they are corporate lawyers. But with due respect to all the corporate lawyers, I remember a senior lawyer told me once, बहस ना कीती ते वकील का दे. He meant कि if you do not argue what kind of a lawyer you are, so even if you want to get into corporate, first spend 2-3 years into litigation. See how the court is, how the legal system works. It will make you more successful. When you get into corporate law, when you get into companies or big law firms, you will have better idea how things are done. And if you have never seen a court, if you have never argued in the court, I would say you are still missing something in your life. So go to the court, first learn, and then take a call whether you want to get into corporate, whether you want to get into litigation. And it is always said, law is a jealous mistress. So law will take a lot of time from you. So be prepared for the challenges. Life ahead is full of challenges and you will love it. I'm loving it.
So I think patience is something that they need to practice from now on.
Law, I would say, compound effect works here. Initially few years, you will think every day, why I have come to this profession.
Right.
But when you shine, when you rise, the rise is phenomenal. It gives you a lot of money, name, fame, everything you get in law.
Right. So I think we've all thoroughly benefited from this session, from this conversation with you. I think the insights that you've shared, they will definitely help our students who are just starting to study IPR. It might even influence a few of them to take up the field in the long run. So thank you so much for taking out time to share your insights with us, to be here.
I can say thanks to you for inviting me, because every interaction I have with young students, it's a tribute to my Guru Ram Jethmalani sir. I still remember his words that the older you get, the younger should be your company, and I'm just following his footsteps. Thank you.
Thank you, sir. I think those were the best words to end on.